Today we're speaking with Maxim Krupskiy. I am Jim O'Neill, and I am a board member of the Advocates for Human Rights. We are an international human rights organization based in Minneapolis. We have, for a number of years now, been working with human rights defenders in the former Soviet Union and Eastern Europe in the hope of providing them support in their very difficult situations there. We are here today to speak with Maxime about the so-called foreign agent laws, which are popping up in Russia and numerous other countries, and how they are being used to threaten human rights defenders. Maxim Krupskiy is an expert on this subject. He is a lawyer and PhD in philosophy. He spent 12 years, more than 12 years, representing human rights defenders in Russia. And the majority of his practice, as his time went on, became focused on Russia's foreign agent laws and representing human rights organizations in connection with those laws. He is now a researcher with a special focus on foreign agent laws. He has been a research fellow at the Wilson Center for Human Rights, a visiting scholar at Fletcher School of Law and Diplomacy at Tufts University, and a non-resident fellow in the Russian program at George Washington University. So we're very happy to have you here. Maxime, let me start with a very basic question. What are these foreign agent laws and what do they tend to provide?
Thank you. Thank you so much for having me. It's a great honor to speak to you. Well, let's say that, first of all, that foreign agent laws exist in many, many countries around the world, in different regions, in countries with different legal background and varying degrees of democracy. And this legislation, with a similar name or similar rhetoric of implementation, exist in Australia, in the United States, in the United Kingdom, in Russia, Hungary, Kyrgyzstan, India, China, Israel, Nicaragua, and many, many other countries. And today, this legislation is being developed in the European Union and Canada. And the most recent and perhaps well-known example is the Georgian law, the Law on Transparency or Transparency Act, which is also very well known because of it's also an example of foreign agent laws, which was adopted in May, amid large-scale protests, street protests against its adoption, because Georgian citizen and civil society actors felt that this law was dangerous and is dangerous to the rights and freedoms of citizens and would lead to repression of NGOs and independent media. So, in general, common to all these laws are the officially stated purposes of their enactment: protection of national security, sovereignty, as well as ensuring transparency of covert foreign influence. And the ideal situation is this: that if a person or organization acts in foreign interests, they must register as foreign agents, and if they fail to do so, they can be prosecuted, including criminally. But again, the devil is always in details, and despite these common rhetoric or officially stated common goals of these bills, the rhetoric used by the authors of this act, the content of the laws and the practice of their implementation in different jurisdictions differ greatly from one jurisdiction to another.
So I have heard governments of totalitarian or wannabe totalitarian systems defend their laws by saying that the United States has this so-called transparency law, Australia does. So what's the furor about our country's law? Is that a fair characterization?
Well, of course, I'm familiar with this, let's say, whataboutism or double standards rhetoric from the so-called non-democratic regimes or authoritarian regimes. I don't agree with that at all, because it's a kind of manipulation and playing with this similar rhetoric, despite the common rhetoric and to some extent officially stated similar goals of these legal acts in, let's say, in the United States and, for example, in Russia. These two acts are radically different. On the one hand, the FARA law from the United States and foreign agent law in Russia on control over the activities of persons under foreign influence. So why I just mentioned that they are radically different. In short, the FARA law provides that in order for a person to be recognized or to be labeled as a foreign agent, there must be a clear link between the activities of the agent and the foreign principal's interests. So what does it mean? The person for whose benefit the agent acts. The FARA Act provides that the agent must act under the control of, or at the direction of, or on behalf of the foreign principal. These circumstances, these criteria must be proven by the state or executive authorities and can be checked by the independent court. So if there is no evidence of such a connection, such a link, the person or an entity should not register as a foreign agent in the United States. And there is no mention in Russian law at all of a foreign principal or of an agent acting in someone else's foreign interests. The executive authorities are not obliged to prove a link between the activities of an agent and a foreign actor's interests, such as for example, foreign government interests or foreign donors' interests. Simply, according to the Russian law, simply being under foreign influence is enough to be labeled as foreign agent. This is a quote from this legal act, to be under foreign influence. And this concept, the concept of a foreign principal in the law doesn't exist in Russian law, and the concept of to be under the foreign influence described extremely broad, and even the state authorities, for example, the Ministry of Justice of the Russian Federation, cannot clearly explain who should be labeled and who should be registered in the register of foreign agents. And I just want to list in a very short manner the grounds on which the Ministry of Justice included new people in this register of foreign agents just a couple of months ago. These are official quotes from the website of the Russian Ministry of Justice. So it's not my, let's say, phrases or something like that. So it's just quotes. Spoke out against a special military operation in Ukraine. Voila, you are a foreign agent. Disseminated unreliable information about decisions and policies taken by the public authorities of the Russian Federation. Participated as an interviewer and responded on information platforms provided by foreign media and foreign agents. So I can be labeled as foreign agent in Russia because of this interview with you.
So if I can break that down a little bit, the laws, foreign transparency law in the United States, for example, requires people who are actually acting at the direction and control of a foreign entity to a foreign government, I should say, to register as foreign agents, so that's transparent. But in the Soviet Union, or I shouldn't say the former Soviet Union countries that have these laws, um, the the law requires you to register uh, basically for a connection with a foreign organization or government without the need to show any control or that you're acting in that organization's interest. Is that correct?
To some extent, yes, with two comments. I should say that in in the FARA law, we also have some lacunes. So there are also some lacunes, but in general, yes, of course, the FARA law requires that the state, the executive authorities, must prove this link between the activities of a foreign agent and foreign principal, that this agent acts in the interests of the foreign principal. I cannot say that the situation with the Russian law is common to all, let's say, so-called post-Soviet space, because it's not fair. And I think that I should mention that for example, in Kazakhstan, situation is very, very different, because in Kazakhstan, there is also a norm about foreign agent activity, but it's not literally foreign agent activity. It's a part of a tax code of Kazakhstan, which requires that those entities and persons which receive foreign funding should be registered in a special list, but it is not a list of foreign agents, because they don't have this term foreign agents, and they I mean the Kazakhstan doesn't have any other obligations and requirements for those people or those entities who are or that are included in this special list. So it's not the degree of repressiveness is very, very different. But in Kyrgyzstan, Kyrgyzstan has a literally copy of the first version of the Russian law on foreign agents. So in this situation, yes, we can say that we have the same law in Kyrgyzstan like in Russia.
What is the effect on human rights organizations or media organizations of being labeled a foreign agent?
Well, first of all, this is a great reputational damage. And again, if you are not acting in the interests of a foreign source, foreign power, or foreign principal, why should you be labeled as foreign agent? So it's simply unfair to be labeled as foreign agent when in fact you are not a foreign agent. You have your own agency, you have your own interests, and you are acting in your own interests or in the interests of your society. So this is the first point. The second point is that after this reputational damage, deprives you of a lot of opportunities to work with governmental organizations, for example, or with media organizations, with common public, because simply these actors, the government, common people, they don't trust you because you are in their eyes, because of this official labeling as foreign agent, in their eyes, you're acting not in their interests, but in the interests of foreign power or foreign principal or foreign government or any other entities or persons. And also, after as we can see in practice, for example, in Russia, after the appearance of this label or this status in the legislation, the authorities can amend again and again this legislation and can create a lot of requirements, obligations, additional bans for those who were labeled as foreign agent. For example, you can be required to make additional reports to the Ministry of Justice, additional financial searches or inspections or something like that. And again, with this status, you get additional risks of potential penalty for non-compliance with this legislation and potential criminal offenses because of this. And you cannot be sure that you are safe in the situation when the government can do anything that it wants towards you on arbitrary manner, just because this law gives a lot of power, arbitrary power, to the official authorities, executive authorities, to do anything with you, without any mechanisms of protection, just because you have this status. So it's the first step of further repressions, and this is the great reputational damage, risks of potential criminal offenses, and so on and so forth.
In Russia, where they have taken these further steps, have you seen human rights defenders actually prosecuted, perhaps human rights organizations go out of business or leave the country?
Well, I think that we can see very clearly in Russia the results of the implementation of these legislation, that in fact those NGOs or independent media or even journalists, just common persons and common people, when they get this status, they also get a kind of a stigma. So a lot of organizations just don't work with this, don't want to work with this status, and they deprive again of the opportunity to interact with governmental institutions, which is very, very important, for example, for, let's say, environmental organizations, when they work in the interests of common people, in the interests of Russian society, in the interests of sustainable development. So they need to work together with governmental organizations, and when they cannot do that because of this status, when they cannot prove in non-independent and fair trials, non-independent courts and non-fair trials, when they cannot prove that they are not foreign agents, they just decide to close down their activities and to shut down the organizations, because it's impossible to work with this status when you want to get some real results in the field of your work. So this
At
is
the advocates, I know that we uh, apply for and receive grants to fund our work from various foundations. If we were to accept a grant from a foreign foundation, even though they exercise no control over us, under these laws, could we be labeled a foreign agent
of
if we
course.
were in one of these countries?
Definitely, of course, because again, there is no clear criteria in the Russian foreign agent law, for example, and of course, if you get some foreign funding, it's, of course, it's enough to be labeled as foreign agent. This is a ground in the eyes of the Russian authorities to be labeled as foreign agent. But even if you share some, let's say, not very popular views, anti-Kremlin views, for example, or if you share anti-war position as a lawyer, and if you work in this field and try to protect those persons, those people who are against the war, you also are at risk of labeling as foreign agent because of these views, because you share these views or act against the official agenda, let's say, official political agenda. And this is the great problem. Again, this is the great problem with this legislation, not only in Russia, but also in Georgia, for example, in Kyrgyzstan, and even in Hungary, by the way. But Hungarian law from 2017 was repealed after the decision of the European Court of Justice in 2020. My point is, of course, every state has the right to defend its sovereignty. That includes also passing laws to ensure transparency. No one denies that. However, again, my point is, very simple point, that transparency laws must themselves be as transparent as possible and consistent with the rule of law. Only then can we be sure that human rights and freedoms will be sufficiently protected from arbitrary implementation of the law. So this is the basic point, the very, very simple idea, I think. And we should try to improve these laws or to reform these laws in this manner. So we should try to do something, and we should analyze this legislation in different jurisdictions from this point of view, from the legal point of view, pure legal point of view. And what does it mean that these law should be in accordance with the rule of law? It means that at least the law must be formulated in a clear and predictable manner. This is the first requirement to this legislation.
You mentioned the European Court of Justice. What positions have the various international justice mechanisms and governmental bodies in the West taken with respect to these foreign agent laws?
Well, I should say that we already have at least two decisions of the international courts. One of the decision is the decision of the European Court of Justice from 2020 about the Hungarian law, so-called Transparency Act from 2017. And another one decision is the final judgment of the European Court of Human Rights about the Russian legislation on foreign agents from 2022. In both cases, in fact, these international bodies ruled that this legislation violates the freedom of assembly and the human rights. And it's very interesting that in Hungarian case, the Hungarian law had the similar structure like the Georgian law, more or less the similar structure. The similarities are this, that first of all, this law is only about the non-governmental organizations, so not about the whole organizations, let's say commercial organizations or governmental organizations. No, just about non-governmental organizations. In Hungary, it was so, like it is now in Georgia. And also, you can be labeled as foreign agent only because you get a certain amount of annual income from a foreign source. In Georgian case, Georgian law provides that it is enough that a non-profit organization or media outlet receives more than 20% of its annual income in form of money or other property from a so-called foreign power in order to be included in the register of an organization carrying out the interests of a foreign power. And this very construction, in fact, is inherently unfair, as the only criterion for an organization to act in someone else's interests is the receipt of foreign funding. And it is, if it is stipulated by default, if you receive foreign money, then you're acting in foreign interests. So the very idea, in short, of this law, Georgian law. And the same situation was with the Hungarian law. The state thus declares in both cases, that receiving a grant deprives an organization of the opportunity to act in accordance with its goals and in the interests of society and ordinary citizens. And again, in my view, this does not correspond to reality. And we already have the decision of the European Court of Justice that such construction violates the human rights and is unfair. And this is the great question for me, because if we already know that this legal construction is unfair, if we already know the position of international bodies about this construction, so why the Georgian law was adopted and why it is in force right now? So I cannot answer this question, and that's why I see this law as unlawful, and I think that I'm sure that this law is not in accordance with the rule of law principles and human rights.
So, Maxime, this will, the people watching this may be human rights supporters in the United States, may also be supporters in other countries, and that includes potentially human rights defenders in the countries where these laws are in effect or are being talked about. What would you advise these people about responding to laws of this sort?
Well, I think that it's very important to do something as civil society actors right from the beginning of, let's say, discussions about the potential adoption of these laws. So civil society actors from the very beginning should try to start a kind of enlightenment campaigns or public campaigns. They should try to explain to the common audience, to people, that what does it mean to adopt or to develop a Transparency Act? What kind of criteria should be in this legislation? What does it mean that the law should meet criteria in terms of the rule of law and human rights? And I think that civil society actors, it doesn't matter if it's independent media or advocacy groups or non-governmental organizations or lawyers, I think that they should explain the very, very simple idea that if the law proposes to label someone as a foreign agent, the law should clearly spell out the criteria for agency activities or activities to represent the interests of a foreign power. The state must provide evidence of a link between the actor's activities and the interests of a foreign principal or foreign power. Simply receiving some foreign funding should not lead to labeling as foreign agents, because, again, it's unfair construction. And this is not only my point of view or the point of view of my colleagues. We already have the position, as I mentioned before, the position of international judicial bodies. So I think that this is very important, again, to explain to people and to try to, let's say, use these energy, these common social forces to do something with this adoption of such kind of legislation, and people should try to demand from the official authorities to create the lawful legislation, which again must be developed in accordance with the rule of law principles. So this is the main advice, because after the adoption of these laws, these bills, it's almost impossible to do something, at least on the national level. You can try to go through the national procedures legal procedures and try to apply to in international courts. But again, as we can see on the example of the Russian Federation, Russian non-governmental organizations now have this decision of the European Court of Human Rights, but we cannot do anything with that. It's like it's already too late. So that's I think the main idea, that you should do something as legal practitioners, human rights actors, and civil society actors right from the very beginning to defend yourself and your own society.
You can see the cleverness of these laws because people don't really understand the complexities, and there is a danger in opposing these laws that you sound like you're against transparency, you're against revealing uh, your connections with foreign entities. And I can see where it is crucial to explain this in very simple terms, that the law is far more dangerous than it's being depicted.
I think, we should try to avoid, and lawyers and human rights defenders and other civil society actors, we should try to avoid overgeneralization. It's really hard to explain with this kind of complexity of this legislation, to explain in general all the details of this legislation. So we should try to use a concrete, specific example. Let's say we are not fans of the Georgian law. Okay, just let's try to look at it. So Georgian law, in fact, does not even meet the stated goals of transparency of foreign influence, because your opponents can say, okay, you are against transparency, you are a foreign agent yourself because you are against this act. Okay, we can ask, okay, so let's take a look at this law, the content of this law. Georgian law does not even meet the stated goals of transparency of foreign influence. Why? Let's assume that an NGO or media organization receives funding from foundations in the United States, China, India, and donations from thousands of citizens at the same time. And in total, it is more than 20% of its annual income. According to the Georgian law, the organization should be registered as foreign agent. Question: whose interests are represented in this case by such an organization, and whose influence is made more transparent? India, China, the United States, or thousands of donors? The law does not give an answer to this question. So it's when you hear, and when your opponents hear some critique towards this legislation, it doesn't mean that we are against transparency, that we are against the protection of national security or sovereignty or something like that. No, it means that we want to have a good law, the law of a good quality. This is the main idea, because if you have this law, so then and only then you can be sure that your rights and freedoms and the rights and freedoms of your neighbors, the whole of your society will be protected in a real manner, and that you yourself will be protected because of this real and good quality of this law. And your fate will not be a result of a kind of arbitrary decision of the executive authorities. So this is the very simple explanation, I think. And if your opponent really wants to understand your position, if your opponent really wants to understand the very idea, the very spirit and the content of the law, I think that you can find a kind of solution and you can understand each other.
Maxime, I think that's an excellent example of the kind of simple and concrete messaging that human rights defenders need to learn to make in order to advance their position. So thank you for that. Thank you for talking with us. Is there anything else, last point you want to make for our listeners?
Well, I think that the main idea for human rights defenders today, and the main advice, just do your job, and that's it. Because this is really, really important to do human rights work, human rights advocacy today in this very, uh, I would say, hard times. And we should not stop to do that. And we should try again and again, explain our positions, and try to reach a broader audience, and try to explain to a lot of people the value and the very spirit of human rights and freedoms.
All right. Thank you so much, Maxine.
Thank you.